Good afternoon and thank you for joining us. I'm Tim Coolican, Partner and Head of Regulatory at Anthony Collins Solicitors, and I'm joined by my colleague Matt Marsh, who's a solicitor in the Governance and Commercial team, with a particular focus on local government. This is the second of two webinars looking at regulatory issues that may impact upon local authorities. Today we'll be covering the Health and Safety at Work Act 1974 and related legislation, the Corporate Manslaughter and Corporate Homicide Act 2007, issues relating to responding to an incident and regulators, the instruction of experts, anticipating the potential outcomes, including prosecution and inquest proceedings. While the previous seminar focused exclusively on situations where regulatory or enforcement action was likely to be taken by a local authority, today we'll be considering issues that may be just or more likely to be relevant where it's the authority that is subject to regulatory or enforcement action itself. Each of the topics that we're looking at could justify their own presentation, and the intention was to provide an introduction to them all. However, we hope that we'll also provide some insights that will also be of interest to those with more experience in this area. Turning first to the key health and safety legislation. Section 2 of the Health and Safety at Work Act places a duty on employers to ensure, so far as is reasonably practicable, the health, safety and well-being of all employees at work. The key phrase is to ensure health, safety and welfare so far as is reasonably practicable. What is reasonably practicable will be judged on a case-by-case basis, depending on the individual circumstances of the matter. The Health and Safety Executive or other enforcement body will consider what was reasonably practicable when deciding whether to take enforcement action, and if so, what action would be appropriate. Should criminal proceedings be initiated, it would be for the court to make the final decision about whether the action taken was reasonable. The legal definition of so far as reasonably practicable is taken from Edwards versus the National Coal Board. This in effect states that an organisation must weigh up the severity of a risk against the resources that would be needed to mitigate or remove that risk. As a side issue, it's perhaps worth noting that the practical challenges faced by all organisations in relation to COVID-19 is something that will have to be taken into account when considering what is or is not reasonably practicable. Employers also have additional obligations under Section 3. This provides that employers must, so far as is reasonably practicable, ensure the health and safety of any non-employees who may be affected by the conduct of their undertaking. This includes members of the public, contractors and visitors. However, it is important to note that this obligation extends to ensuring health and safety rather than health, safety and welfare as set out in Section 2. The additional obligation to ensure employees but not third parties' welfare underlines one area of increasing focus. The Health and Safety Executive have made clear for a number of years that they will be paying additional attention to workplace stress and mental ill health. In the last week, the Health and Safety Executive have released statistics indicating that more than half of Britain's working days lost in 2019-20 were due to mental ill health. Section 4 of the Health and Safety at Work Act imposes duties in relation to the safety of premises and plants and requires those with control of property to take such measures as is reasonable for a person in his position to take to ensure the safety of those using the property for work purposes. In the words of the leading authority of Austin Rover Group, the ambit of Section 4 is far wider than that of Sections 2 and 3. It applies to anyone who's in occupation of non-domestic premises and who calls in tradesmen to carry out repairs. It applies to those tradesmen in relation to the employees of others, and it applies to anyone who makes the premises available on a temporary basis for others to carry out work in. As well as placing duties on employers, the Health and Safety at Work Act also places duties on employees to take reasonable care for their own and others' safety. It creates the potential for prosecution of directors and senior officers if a health and safety offence is committed with their connivance, consent or neglect. It provides for health and safety regulations and codes of practice to be made, and gives the Health and Safety Executive or local authority inspectors permission to enforce health and safety laws. Under the Act, inspectors are given extensive investigative powers and can serve enforcement notices in the form of prohibition and improvement notices, and bring prosecutions for health and safety offences. Importantly, it's not necessary to show actual injury or ill health, and an offence can simply be committed when an individual is exposed to risk. Turning now to corporate manslaughter. The Corporate Manslaughter and Corporate Homicide Act 2007 came into force on the 6th of April 2008. The Act creates the offence of corporate manslaughter for organisations and was brought in to overcome the difficulties in securing convictions against corporate bodies for manslaughter by gross negligence. Prior to the Act coming into force, a corporate body could only be convicted of manslaughter if it could be shown that an individual offence of gross negligence manslaughter had been committed by someone in such a senior position that they could be seen as the directing mind of the organisation. As a result, convictions were largely limited to small organisations, often where the director was personally involved in the day-to-day work. For example, the prosecution of an outdoor pursuits company, where the sole director led a fatal sea kayaking activity with school children. An organisation will be guilty of the offence if all of the following three factors apply. Firstly, the way in which its activities are managed or organised causes a person's death. The person's death is the result of a gross breach of a relevant duty of care owed to that person. And thirdly, the way in which the senior management managed or organised the organisation's activities is a substantial element of the breach. In this context, a gross breach means conduct that falls far below what can be reasonably expected of the organisation in the circumstances. The Act also sets out certain factors that a jury must take into account when deciding whether an organisation is guilty of the offence. These include whether the organisation was in breach of health and safety legislation, how serious the management failure was, how much of a risk there was of death occurring. It also sets out a non-exhaustive list of factors that a jury must take into account, including any health and safety guidance relating to the breach, and whether there were any attitudes, policies, systems, or accepted practices in the organisation that were likely to have encouraged a management failure. The offence applies to all organisations operating in the United Kingdom, including companies, partnerships, trade unions, and certain government departments and public bodies, as well as the police service. In that context, however, it's important to note that Section 3 expressly excludes potential liability under the Act arising from purely public policy decisions, exclusively public functions, and statutory inspections. On conviction, the maximum penalty is an unlimited fine, and in addition, the court has additional powers. The court can order a remedial order, forcing an organisation to remedy the management failure that caused the death. It can also order a publicity order, which forces the organisation to publicise the conviction. When the Act was introduced, the common view was that it would transform how serious health and safety incidents were dealt with in the United Kingdom. Its impact has perhaps not been as significant as first thought, but there have been a steady flow of prosecutions and convictions. In the course of 10 years, there have been a total of 25 convictions. In nearly half of those cases, there was also a conviction of a company officer or an individual for health and safety offences or for gross negligence manslaughter. And disqualification of directors occurred in approximately 1 in 5 cases. Under the Sentencing Council guidelines that Matt will be speaking about in a moment, the starting point fine for an organisation with a turnover in excess of £50 million is between £5 million and £7.5 million. And even for an organisation with a turnover of between £10 and £50 million, the starting point fine would be between £2 and £3 million. And it is those Sentencing Council guidelines which have arguably had a greater impact in terms of the health and safety landscape in the United Kingdom, so that health and safety breaches are now seen as being a serious and significant criminal offence and not merely a technical regulatory breach. And at that point, I'll hand over to Matt to speak about the Sentencing Council guidelines.
Thanks, Tim. Morning, everybody. The health and safety offences, corporate manslaughter and food safety hygiene offences definitive guideline came into force on the 1st of February 2016 and are for use in both magistrates and the Crown Court. The guidelines are set out into or include 5 separate guidelines within the whole of the guideline document, as it were, and they concentrate on the Health and Safety at Work Act 1974, dealing with the section 33(1)A and section 33(1)C offences, which is a failure to discharge a duty imposed by the Act to employees and non-employees, and contravention of health and safety regulations. The second guideline concerns the Food Safety and Hygiene England regulations, and deals with offences under Regulation 19(1), which is contravention of specified EU provisions. The third guideline is for Food Hygiene Wales Regulations 2006, which again deals with contravention of specified community provisions under Regulations 17(1). Then there is Guideline 4, which deals with the General Food Regulations 2004. So Regulation 4 is again contravention of EU regulations pertaining to the general food. Article 14(1), food safety requirements. Article 16, which is presentation of foodstuffs. Article 18(2) or 3, which deals with traceability of food sources within and or as relates to food business operators. And Article 19 is again for food business operators and deals with their responsibilities for food. And then finally, the fifth guideline pertains to the Corporate Manslaughter and Corporate Homicide Act 2007 and deals with Section 1, which are offences where an organisation has been managed or organised in such a way as to cause a person's death or amounts to a gross breach of a relevant duty of care owed by that organisation to the deceased. It's important to note as well at this point that following the Sentencing Council's issue of general sentencing guidelines in October of last year, the health and safety definitive guidelines also apply to analogous offences where there isn't actually a sentencing guideline for that particular offence. So on that basis, the health and safety guidelines are going to be highly relevant to a number of other regulatory offences. So prosecutions undertaken by the Care Quality Commission and also regulatory offences coming under the fire safety regulations. So where there aren't specific guidelines for those offences, then the health and safety guidelines will be taken into consideration. And when the guidelines are considered in this context, then there will be adjustments will be need to be made to the statutory, the definitive guidelines as regards any maximum sentence specified in the legislation for the offence. So the health and safety guidelines very much follow a model which is focused on 4 key elements, which is firstly looking at the culpability of the offender, and then the risk of harm created by the offence in question, the likelihood of harm resulting from that offence, and the level of actual harm that did. The penalties provided by the guidelines, as Tim has said, differ for the size of organisations, which are categorised as micro, small, medium or large, and the size of an organisation is determined by the organisation's annual turnover. The offences can be tried summarily or on indictment, and with the sentencing range starts at an unlimited fine and can be a fine of £50 up to 10 million. Individuals can also be tried summarily and subject to an unlimited fine or 6 months custody. And the sentencing range is from a conditional discharge to 2 years imprisonment. The guidelines, as indeed all the sentencing guidelines are, which some of you will undoubtedly be familiar, are set out in a number of steps. So step one first looks at determining the offence category, and that's where the consideration of culpability and harm comes in. And the culpability, again, is divided up into 4 levels. So very high, medium or low. And determining the culpability essentially requires the court to balance the offender's actions with the appropriate standard. And the appropriate standard itself will look at whether or not any measures were in place that were recognised as the industry by as standard measures or procedures, whether or not the offence has resulted from the organisation ignoring concerns that may have been raised by employees or other persons, whether the organisation has failed to make appropriate changes to their practice and procedures following previous incidents, and whether or not the breach in question has been allowed to subsist over a long period of time. So taking those elements into consideration, the court will then determine whether or not the culpability of the offender is very high, which they will do if there has been a deliberate breach or a flagrant disregard for the law. Where an offender is deemed to have fallen far short of the appropriate standard, then the culpability will be high. If the offender falls short of appropriate standard between high and low, their culpability will be determined as medium. And where the offender did not fall far short of the appropriate standard, but nonetheless did fall short to an extent, then the culpability determination will be low. So once culpability is being considered, then the court will go on to look at harm. As Tim said, health and safety offences are based on a risk of harm, not actual harm. So that's a balance of the potential type of injury that could be caused with the likelihood of this injury actually occurring. There is also the potential for the court to jump between the different harm categories if the offence in question exposed a number of people to the risk of harm, or if the offence was a significant cause of actual harm. So the harm again is divided into high, medium and low likelihood. So that's level A, B and C. A being most serious, which is death or physical and mental impairment, which results in lifelong dependency on third party for basic needs, or a significantly reduced life expectancy. So once step one has been addressed and the culpability category has been determined and the harm has been assessed as high, medium or low, the court will then move on to step two and we'll consider the starting point and the category range. And it's at this point that these features can be upped, so to speak, depending on the adjustments the court makes for any aggravating or mitigating factors which might be present. So the starting point in the category range, again, based on the annual turnover of the company, the harm category identified in the previous step, and likewise the culpability. And in determining the turnover of a company, or an organisation will require that organisation to serve on the courts its accounts and financial information. Aggravating and mitigating factors, as I said, can be used to adjust the starting point and the category range. The guidelines set down a number of factors which can be considered as both for aggravating and mitigating factors. And they will include statutory aggravating factors such as previous convictions, and also a number of non-statutory aggravating factors which include the organisation taking cost-cutting measures or deliberately concealing an illegal activity. Mitigating factors include no previous convictions or no relevant or recent previous convictions, any steps the organisation has taken voluntarily to remedy the problem, a previous good health and safety record, and cooperation with the investigation which goes beyond the level that is ordinarily expected. Step 3 and step 4 is where the court is encouraged to step back, review and adjust the sentence to ensure that it fulfills the sentencing objectives. Step 5 then goes on to consider factors indicating a reduction in sentence. So that will be any assistance that has been afforded the prosecution, and also provides that where the offence has been committed by a public or charitable body, that a sentence may be reduced at the discretion of the sentencing judge, but should ordinarily only be reduced significantly if the organisation can demonstrate that any proposed fine would have a significant adverse impact on the provision of its services. Step 6 is the reduction for a guilty plea, and as you probably know, an offender can receive up to a 1/3 reduction from their sentence if they enter a guilty plea at the earliest opportunity. So once those 7 steps have been considered, the court will pass down the sentence. And as Tim has said, the Sentencing Council recently undertook a review of the impact and the implementation of these definitive guidelines, and made a number of quite interesting findings. Firstly, that the majority of organisations sentenced for a Section 33(1)A offence, that was 60% of organisations sentenced under the guidelines that committed a Section 33(1)A offence, and the majority of the remainder been convicted of a Section 33(1)C offence. Between 2011 and 2015, so that's before the guidelines came into force, over half of organisations sentenced for health and safety offences were sentenced in the Magistrates' Court, and following the coming into force of the guidelines, that was reversed in 2016. And in 2017, more than half of those organisations were then sentenced in the Crown Court. The Sentencing Council found that generally the guideline is being applied by both the magistrates and the Crown Courts as they were intended to be. The majority of organisations sentenced under the guidelines, that's some 99%, were sentenced to a fine. And there has been, as Tim mentioned earlier, a significant increase in the level of fines imposed on organisations that have been convicted for health and safety offences. And that was anticipated by the Sentencing Council, who found that in the 10 months before the guidelines came into force, The mean fine for an organisation convicted was £40,500, with the median being £12,000. And in the 10 months after the guidelines came in force, that mean had increased to £221,700, with an increase in the median fine to £60,000. And since the guidelines have come in, the median fine for large organisations has increased from £25,000 to £370,000. So you can see that they've had a significant impact on the level of fines being imposed on organisations that have been convicted for health and safety offences. And there was also a significant increase in the fines imposed on individuals, which apparently the Sentencing Council hadn't anticipated to the same extent. And again, the 10 months post guideline suggested that the mean increase had increased from £6,300 to £8,200 for individuals, and the median had also increased from £3,000 to £5,000. Lastly, a quick look at the appeals, and again, the research undertaken by the Sentencing Council found that since the introduction of the guidelines, there have been significantly fewer appeals against a manifestly excessive sentence, and that where those appeals had been heard by the Criminal Court of Appeal, the higher number of them have been dismissed, and the Court of Appeal held that the Crown Court judges were correctly categorising the offence categorisation, and the starting point was also found in such cases to be in the appropriate range. In summary, since the sentencing guidelines have come into force, there has been a significant increase in the level of fines imposed on both organisations and individuals for offences, particularly under the Health and Safety Act, and that where those higher sentences have been imposed, the number of successful appeals against the sentence to the Crown Court has reduced. I shall now pass you back over to Tim.
Thank you very much. I now wanted to focus a little on the use of expert evidence. An expert witness can give opinions to assist in resolving issues concerning matters of knowledge which can only be acquired by special training or experience. Their role is to assist the court or jury on matters where their ordinary everyday experience doesn't enable them to adequately consider the issues in the case. In health and safety cases, an expert may be able to assist a court or jury in understanding the relevant factual or technical background needed to help them decide whether there's been a failure to take reasonably practicable steps. The health and safety cases that I've been involved with during my career range from a fatal explosion in a blast furnace, the death of a diver trapped underwater whilst carrying out repairs to a canal lock, through to deaths and alleged failings in mental health and social care settings. Juries can't be expected to master the precise duties that arise in those cases based on their own knowledge, and expert evidence will be critical in assisting reach safe conclusions. Given the increased level of fines, expert evidence can also be highly effective in submissions around the correct assessment of risk and culpability during the sentencing process. For example, in a recent case, we were able to use expert statistical evidence to convince the health and safety executive to drop an argument that a fall from a height of around 6 metres carried with it a high risk of death. The agreed reduction in the assessment of risk undoubtedly had the effect of reducing the likely sentence by hundreds of thousands of pounds. An expert's opinion, however, must be objective and unbiased. Their obligation is to act in the cause of justice, and their duty to the court overrides any obligation to the party instructing them. Any correspondence with the expert relating to their instructions may well be disclosable. Where the expert is instructed by the prosecution, the defence will be entitled to see the instructions, and in appropriate cases, the court can ask to see instructions provided to a defence expert, which could include additional emails or telephone communications. From a defence perspective, that requires particular care to ensure that the use of an expert does not undermine legal professional privilege. When sending instructions, the expert should be reminded of their obligation to act impartially and their overriding obligation to the court. Careful thought needs to be given about what material to send to an expert to ensure that it allows them to come to a fair and balanced view. Any selective approach to the material that is sent is likely to undermine the credibility of an expert's report, and any material provided to the expert should be listed in the original and any subsequent written instructions. From a prosecution perspective, the expert should not be given material such as internal prosecution or investigation reports, which are likely to contain opinion evidence from people other than witnesses of fact or other experts, to avoid any suggestion of improper influence. In one case that I dealt with, an expert was put forward as having undertaken an expert audio analysis of what could be heard on a CCTV recording, only for their evidence to be ruled inadmissible because they'd been given a draft transcript of what the investigator thought they could hear based on their wider knowledge of the case. In the same way, care needs to be taken to ensure that any work conducted by an expert complies with the investigator's duty to consider all reasonable lines of inquiry, whether they might prove or disprove the potential prosecution case. Bearing in mind that the defence are entitled to see all material provided to the expert by those instructing them, sensitive or privileged material should not be supplied. We should look briefly at the admissibility of expert evidence and 4 factors that will need to be established. First, the expert evidence must be of assistance to the court. For expert opinion to be admissible, it must be able to provide the court with information which is likely to be outside of the judge or jury's knowledge and experience, but it must also be evidence which gives the court the help that it needs in forming its conclusions. The role of the expert is to give their opinion based on their analysis of the available evidence, and the judge and jury are not bound by that opinion, but can take it into consideration in determining the facts in issue. Secondly, the expert must have relevant experience. The individual claiming expertise must have acquired that expertise by study or experience of a sufficient knowledge of the relevant field to render their opinion of value. Thirdly, the expert must be impartial. They must be able to provide impartial, unbiased, objective evidence on matters within their field of expertise and must not stray into the role of becoming an advocate. The final point is that the expert's evidence must be reliable. There should be a sufficiently reliable scientific basis for the expert evidence, or it must be part of a body of knowledge or experience which is sufficiently organised or recognised to be accepted as a reliable body of knowledge or experience. Criminal Procedure Rule 19 states that an expert's report must contain a number of prescribed features, which I've outlined in the slide. I apologise for the small type, but the slides will be circulated after the presentation. The relevant points include details of the expert's qualification, relevant experience and accreditation, a statement setting out the substance of all facts given to the expert, which are material to their opinion, which of the facts stated in the report are within the expert's own knowledge, details of any third-party examination or test that they have relied upon. And where there is a range of opinion on the matters dealt with in the report, they must summarise the range of opinion fairly, outlining the reasons for their own particular conclusions. If the expert is not able to give his opinion without qualification, they must make that qualification clear. And then they must finally include a summary of the conclusions reached and a statement that the expert understands their duty to the court and has complied with it, along with the same declaration of truth as any ordinary witness statement. It perhaps goes without saying that any party seeking to rely on expert evidence must serve it in advance. The criminal procedure rules require that expert evidence must be served on the court and the other parties to the proceedings as soon as is practicable. The report must be served with anything of which the party is aware which might reasonably be thought capable of undermining the reliability of the expert's opinion or detracting from the credibility or impartiality of the expert. The rules also provide that on request, any party relying on an expert report must assist in allowing access to a record of any examination, measurement, test or experiment on which the expert's finding and opinion are based. The criminal procedure rules also encourage courts to manage the expert evidence in a case through joint prosecution and defence expert reports and case conferences between experts for each party. The aim is to limit the issues in dispute, ensuring that the court can focus on the key issues in the case and have a clear understanding of each issue. The court can direct that experts meet to discuss the case and prepare a statement for the court of the matters on which they agree and disagree, giving their reasons. The fundamental principles relevant to the case and any points of agreement can then be dealt with by way of formal admission, leaving the courts to decide upon the issues in dispute. Case law has made clear that these meetings should take place in the absence of legal representatives, with a careful and detailed minute prepared for the purposes of disclosure. The Court of Appeal has also made it clear that failure by the prosecution or the defence to comply with what is now Criminal Procedure Rule 19 could result in a ruling by the trial judge that expert witness should not be called. At this point, I wanted to look at 3 recent examples of prosecutions of local authorities, which demonstrate a number of the points that we've been considering. In a very recent case, the council was fined £104,000 after it admitted that no risk assessments were in place for the protection of staff at a secondary school. The prosecution was brought by the Health and Safety Executive after a pupil assaulted a teacher. On the 17th of June 2016, the assistant head teacher was called to deal with a disruptive pupil who was refusing to go into a detention room. After she cleared the classroom of the other pupils, the pupil launched a sustained assault on the teacher using a mobile phone, inflicting life-changing injuries. Health and Safety Executive investigators found that there were significant shortcomings in relation to the measures of the school regarding violence and aggression posed by the pupils to others. No effective consideration had been given to the risk of injury or death posed by pupils to others, and measures were not taken to reduce that threat to as low as reasonably practicable. The council was prosecuted on the basis that it had failed to ensure that the school had people with sufficient competence in the management of health and safety involved in running the school to ensure that the threat was addressed, or to make sure that staff members at the school had the training either to deal with violent and aggressive pupils or to monitor the adequacy of the measures the school had put in place. Of note, given that the sentencing hearing took place about 2 weeks ago, the fine was reduced from £300,000 due to the council's lack of revenue as a result of the coronavirus pandemic, perhaps reinforcing one of the points that Matt recently made in relation to the Sentencing Council guidelines. The second case relates to a prosecution by the Care Quality Commission after a resident of a council-run care home suffered multiple rib fractures and damage to her lung after a fall. On investigation, the CQC found that the council's falls policy was out of date. Despite previous falls, the council had not carried out an assessment of the resident's care requirements and had not put in place measures to protect her from falls. There was also found to be a shortage of senior staff at the home due to internal staffing issues within the council. The council pleaded guilty to breaching regulations 12 and 22 of the Health and Social Care Act Regulated Activities Regulations and was fined £500,000. The judge, hearing the prosecution, commented that the fine would have been higher had the council not entered an early guilty plea. The third prosecution arose after a 6-year-old girl climbed onto a hinged iron bollard in the street. The 69-kilogram bollard fell to the ground and pulled the young girl with it, resulting in life-changing head injuries. The bollard had been damaged previously and was inadequately secured. The Health and Safety Executive's investigation concluded that the council had received a report regarding the state of the bollard before the incident. Yet the monthly inspections by the Highways Department personnel did not pick up on the issue. The Health and Safety Executive alleged that the Highways personnel received inadequate and in some cases misleading training guidance and information in order to assist them in carrying out ad hoc and routine inspections. The council was found guilty after a trial of breaching Section 3(1) of the Health and Safety at Work Act and was fined £1.4 million and ordered to pay full costs of £130,000. In the reverse of the previous case brought by the CQC, in this case it could be said that the fine would have been nearly £500,000 lower had the council pleaded guilty, demonstrating the increased financial impact of the decision whether to contest allegations at trial. I now want to look briefly at how to respond to an incident and to regulators. Workplaces need to plan for emergencies, as in an emergency, people are more likely to respond effectively if they've received training, have regular and realistic practice so that they can have a clear understanding of what is required. It isn't possible to cover in detail today how to prepare an emergency plan, but the first questions on responding to an incident must be whether everyone is safe, whether the scene is safe, and if not, what action needs to be taken and what support needs to be obtained from the emergency services or appropriate specialists. The second issue to consider is whether the incident is likely to be subject to immediate investigation by the police or other regulators. It will be important to ensure that no one disturbs the scene or removes items until given permission to do so. Even if the police or regulators will not be undertaking an investigation, consideration should be given to how evidence at the scene can be documented, including observations, sketches, measurements, photographs, and plans. A note should be made of all relevant witnesses who may be able to assist in identifying what happened and why. Arrangements should be made as early as possible to collate all relevant documents such as risk assessments and policies. Again, care will need to be taken in relation to the retention of all relevant records. Events in recent weeks of the Grenfell Tower inquiry have highlighted concerns about the potential destruction of relevant notes and records. Care also needs to be taken in relation to the timing of obtaining accounts from the staff involved. Following any serious incident, senior management and potentially regulators will want to know what happened as quickly as possible. However, in some cases, it can be counterproductive to obtain a full written account from employees involved in a traumatic incident. At an initial stage, there may be merit in simply taking a short, brief account to ensure that the key points of their involvement are understood, and it may be better to leave obtaining a full account until they've been able to collect their thoughts and give a clear and coherent account. It will also be necessary to consider what welfare support employees may require, both in recovering from the impact of the incident and ensuring that their involvement in an investigation does not make things worse. At the same time, care will need to be taken about the potential for disciplinary or even criminal investigation of the staff involved, and to ensure that steps taken during the response to the incident do not undermine their rights during HR or external procedures. There will also be a need to consider whether reports need to be lodged with any regulators. The most obvious example is matters which need to be reported to the Health and Safety Executive, as set out in the Reporting of Injuries, Diseases and Dangerous Occurrences regulations, otherwise known as RIDDLE. That requires employers or those in control of premises to report work-related accidents which cause death, work-related accidents which cause certain serious injuries, diagnose cases of certain industrial diseases, and other dangerous occurrences. In that context, it is important to be aware that the Health and Safety Executive have issued detailed guidance in relation to COVID-19 and the circumstances in which a positive test or the death of an employee from COVID-19 will need to be reported. Where local authorities are responsible for the direct provision of social care, they will also need to consider those matters which need to be reported to the CQC, including abuse, deaths, serious injuries, matters under a police investigation, and serious events which impact upon service delivery. It will also be important to notify insurers, both in relation to the potential for civil claims and for support in relation to any inquest or enforcement proceedings. Following almost all serious incidents, there will be a need to conduct an internal investigation to obtain a clear understanding of what happened and why, as well as to ensure that steps can be taken to prevent the same thing happening again. A clear and thorough investigation report will also assist in responding to any civil claims, the preparation for an inquest in the event of a fatality, and to guide the response to any regulatory investigation. There is a need to ensure that internal investigations do not interfere with police and regulatory investigations in a way which can lead to criticism of the organisation. As a result, consideration should be given to the timing of any interviews with the staff concerned, especially if they're likely to be interviewed by the police or regulators. The level of investigation and the detail required will obviously vary from case to case. In serious cases, consideration should be given to conducting a report under legal professional privilege. Whoever conducts the investigation must have sufficient skills and experience and also be given sufficient time and resources to complete the investigation effectively. And they should, importantly, be given the full support of senior management. When it comes to the conclusions made in reports, the key is to ensure that any reports and their conclusions are clear, transparent, and honest. Any attempt to distort or hide the truth will almost always backfire. However, there is also a need to avoid being unnecessarily critical. It's important to stick to the facts, to outline objectively what went wrong, and to identify opportunities to improve. But it can also be incredibly damaging to go on to list every single regulatory obligation that the investigator considers the organisation has breached. Unless reports have been conducted under legal professional privilege, they will be potentially disclosable to a regulator or a coroner, and unnecessary concessions and self-criticism can be damaging at a later date. I'm not an employment lawyer, so don't intend to dwell on the potential HR issues that may arise from a serious incident. However, we are often asked what action an organisation should take about disciplinary issues to improve their position in relation to potential regulatory or inquest proceedings. The short answer is to always deal with disciplinary issues on their merits and never let the potential impact on enforcement action dictate the internal action that is taken. Doing so risks undermining the fairness of the HR process and may undermine the credibility of the organisation. In the final part of our webinar, I wanted to look briefly at inquests. An inquest is a fact-finding investigation into deaths where the cause of death is unknown or has arisen from unnatural causes. They're designed to be inquisitorial in nature, with the coroner keeping responsibility for establishing the answer to 4 questions. Who died? Where did they die? When did they die? And how did they die? There are no parties to an inquest, and in theory, no one is seeking to bring or contest a particular claim. In most inquests, the focus of the investigation will be narrow, seeking to establish the key facts relevant to the medical cause of death. However, the remit of the coroner extends to ensuring that the full facts are brought to light, culpable and discreditable conduct is exposed, unjustified suspicion of wrongdoing is allayed, dangerous practices are rectified, and those who've lost their relative can have the satisfaction of knowing the lessons learned may save the lives of others. Where the death may have been contributed to by the acts or omissions of the state, a wider investigation will be required to comply with Article 2 of the European Convention on Human Rights. In such cases, the question of how the deceased died can be expanded to include an examination of the wider circumstances in which the deceased came to die, including examination of any failings by public bodies. Most inquests will be heard by the coroner alone, keeping responsibility for any factual conclusions. In a limited number of cases, a jury will be called to reach conclusions in relation to the facts. Those cases are where the deceased died in custody and a coroner has reason to suspect the death was a violent or unnatural one, or the cause of death is unknown. Death resulted from a notifiable accident, poisoning or disease and needed to be reported to the Health and Safety Executive. These will include deaths caused by an accident in the workplace, and they also cover deaths in healthcare settings. In addition, an inquest into a death may be held with a jury if a senior coroner thinks that there is simply sufficient reason for doing so. But unlike criminal trials, the jury will be comprised of 11 rather than 12 members of the public. Where possible, the coroner is encouraged to record a short form outcome, stating whether the deceased died from natural causes, the death was alcohol or drug related, arose from a road traffic collision, suicide or accident, or whether the death arose from a lawful or unlawful killing. A rider that the death was contributed to by neglect can be added to short form outcomes, where the coroner or jury conclude that the death arose from a gross failure to provide basic care to someone in a dependent position. For example, that could include a person receiving care in their home who was malnourished because care workers did not provide the support that they required. Where a coroner decides that a short form conclusion cannot satisfactorily reflect the circumstances of the death, they can give a narrative conclusion, which should be a brief factual description. While this must not include any words that suggest criminal or civil liability, they can use words to make clear where the coroner or jury conclude that there have been failings on the part of the organisations and individuals involved. A coroner also has a statutory duty to issue a report where they identify failings which, if left uncorrected, could lead to future deaths. In many cases, it is possible to convince a coroner not to issue a report where they identify failings, provided the organisation can demonstrate that adequate action has already been taken to prevent a reoccurrence. In many cases, regulators and the police will play an active part both in supporting the coroner's investigation and during the hearing itself, with the risk that evidence that is uncovered or highlighted during the inquest can cause reconsideration of whether enforcement proceedings should be taken. While the family of the deceased will always be regarded as an interested person, the individuals and organisations involved will only be regarded as an interested person if there is a basis for thinking that they may be subject to criticism during the inquest process or in the outcome. The significance of this is that only interested persons have a right to legal representation and to receive disclosure of the wider evidence from the coroner. In most cases, the coroner will make the decision about who is an interested person from the start. In other cases, a coroner may request evidence from an organisation without any indication as to their status. Careful consideration will need to be given whether to make representations to the coroner positively seeking interested person status or not. While it can seem counterproductive to suggest to the coroner that they may want to be critical of your organisation's conduct, the ability to play an active part and to obtain all relevant evidence can ensure that there is less risk of an adverse outcome and publicity overall. In preparation for an inquest, a coroner will request documentation to assist them reach their conclusion, and they have wide-ranging powers to compel the production of documents and the attendance of witnesses. Careful preparation is always required, with well-structured statements and a well-organised evidence is likely to assist in presenting the organisation concerned in a better light. In addition to contemporaneous documents and records, coroners are likely to want a detailed statement from individuals who had dealings with the deceased in the lead up to their death, and from managers able to provide an overview of the organisation's involvement. A well-composed statement may reduce the need for the employee concerned to attend the inquest to give evidence in person. Even if they are called to give evidence in person, a clear and thorough statement will assist them in collecting their thoughts as they prepare to give evidence. In appropriate cases, consideration should be given to ensuring that employees called to give evidence are provided with appropriate legal support to ensure that they know what to expect and what they should do to prepare. Consideration should also be given to the preparation of a corporate statement outlining the action that has been taken since the death to make improvements to policies, procedure, and to ensure that any lessons have been learned and addressed. Once again, this is an issue that requires careful thought, as providing a statement may serve to underline the fact that an organisation considers that they made mistakes. But where that is the case, it will almost always be better to show that those mistakes have been addressed and to minimise the risk of a report to prevent future deaths. That brings us to the end of this introduction to the issues outlined during the course of the webinar.